Well, basically, Stephen, the arguments this afternoon and most parts of the morning, you would have heard then Advocate Dalimpofu arguing about the broadened definition of the title to prosecute. But I actually just want to bring the NPA's Mthunzi to speak about this then, because this morning when I spoke to you, when we discussed a possible solution that was suggested by actually our legal expert here about possibly removing Billy Downer as the lead prosecutor but keeping him in the prosecutions team, you said he's going absolutely nowhere. Judging from the arguments that were made here today, do you still stand by that statement?
I stand by that statement because it would be a very bad and wrong precedent to set that when there are speculative allegations made against our prosecutors, we just simply remove them. Until such time that there's a judgment that goes all the way to the Supreme Court to the Constitutional Court that pronounces on his eligibility to prosecute, we will still keep him.
Let's bring in then Mzwanele Manyi, who speaks for the Jacob Zuma Foundation. Please just stay there, Mr. Mhaga, because you feel strongly, or let me say, the former president feels strongly about the presence of Billy Downer in this matter. But again, is it not contradictory that the former president is saying that justice delayed is justice denied, but he's still continuing with all these court processes when in fact this trial could have gone underway on the 11th of April?
The state is delaying the case. It's a simple thing. The state can't be telling us that only Downer and Downer only can do this case. They've got all the records, they've got everything. If they were serious about this case, they would have long removed Downer. We have a situation here where this is not just pure speculation about the conduct of this guy. We've got a sworn affidavit from Hofmeyer that says all kinds of rot that was happening in the NPA that Downer is implicated in. Now, if this court is going to ignore that without even taking that through a trial, that on its own is a travesty of justice. So we are saying justice must be seen to be done. We can't have a situation where such strong statements are made under oath, not just by anybody, by another senior member of the NPA. This is not just some man on the street. This is somebody that understands processes. So if that person makes these allegations, this court is obliged to take that seriously. So we're saying our case is very strong, and also we have a situation where Downer himself, the admission that he has made of leaking documents actually constitutes a crime, which has been reported. So what we're sitting with here now, we're sitting with a compromised prosecutor. We're sitting with somebody that has got a criminal charge hanging over his head. How can justice be seen to be done when such a person is going to prosecute another person?
But if I remember correctly, and let me bring in Mthunzi again, it was Willie Hofmeyer, who was the deputy NDPP, who actually withdrew those comments, isn't it, and actually said that the decision not to prosecute the former president was incorrect. Isn't that not correct?
Certainly, and remember that I've said what the defense is doing is rehashing the issues that were properly ventilated in the full court here when the permanent stay of prosecution's issue was ventilated, as well as the Supreme Court of Appeal, which ruled that these charges should be reinstated. And all these issues that Mr. Manyi is referring to were dealt with by that court, competent court. That's why I'm saying even if they would take it to the Supreme Court of Appeal, they would be shown the door.
All right, let me thank both gentlemen, Mzwanele Manyi, who speaks for the Jacob Zuma Foundation, as well as Mthunzi for the National Prosecuting Authority. Someone who is listening closely, Stephen Kotes, is Mpumelelo Zikalala. You've heard what the two gentlemen have had to say. Let's just get into the meat of what came out in court here today. Dalimpofu saying the title to prosecute and the way in which it was interpreted by this court has been incorrect. And the NPA saying, well, absolutely not. And in fact, you are actually just further kicking the can down the road.
Definitely moving towards the narrow and the wide interpretation, with the NPA saying that we choose to adopt a narrow interpretation. It's purely administrative. The law is very clear. You have the Parrot case that have decided as to what does it mean to say that a person has no title to prosecute. Now, the former president's legal team saying, let's use a wider interpretation. We have a unique case here where a prosecutor is engaged in activities in a conduct in which, in inverted commas, in unbecoming of a prosecutor. How then do you seek to protect the interests of the rights of the accused in this case in terms of making sure that the Section 35 rights are protected? So if that's the type of interpretation that you must use, let's adopt the wider interpretation. Nonetheless, there is no prejudice which is going to be suffered by the state if we take this matter to the SCA. At least we'll come back 6 months to a year down the line with a clear picture as to what exactly should happen. Let's prevent the harm from taking place in terms of the matter or the trial going through, and only at a later stage you then discover that indeed they were right. It does not have the title to prosecute if you use the wider interpretation. So that was the basis of what the legal reps of the former president were saying. In addition to that, they were saying, we have new information that we want to bring to the fore. We have new information and affidavits in which we want to submit, possibly viva voce evidence at a later stage. Allow us that opportunity, because it is important that when you make that particular decision, you are fully traversed and fully informed as the court as to the basis of what the decision is required. And then the judge passing a few comments of saying, why didn't you bring this information at an earlier stage? What was the issue within that particular point in time? And then the response was, well, it hadn't happened at this stage. However, what you must remember is that there were already allegations of certain types of misconduct that has taken place. The matter in which the former president went to open the case on, I think that is maybe a recent matter, although I stand to be corrected. Now the question would be, had you known that all these things were taking place, especially when you're making stay of prosecution applications and all the others, why didn't you go to the NPA and lay a complaint and say, a member of your firm, a member of your department as the NPA has done something which is totally wrong. Here I have an affidavit which is disposed to by him when he was not supposed to do that. Disclosing information which is given to him within the course and scope of his employment, which is confidential. Take steps now before I move on. It is only after there are certain events that have taken place that you then find complaints being made to the President, being made to the Minister of Correctional Services and Constitutional Justice, which at the end of the day one may ask, aren't they a bit too late to come to the fore? But what would be important for this court is to say, let us look at the interest of justice here. Let us look at the interest of all the other accused persons that may come after the former president when it comes to these matters. How then do you deal with instances where the conduct of the prosecutor is such that all can be deemed to have interfered with the rights in terms of Section 35? Do we have certain stops or maybe safeguards within our legislation as we speak that will be able to prevent those injustices from taking place? If they are, let's dismiss this application and make sure that they continue with the trial. But even then, they can still go to the SCA and petition the SCA and say, your learned brother has refused us access, please grant us access, or even to the Koen court.
And certainly Judge Koen also raising the issues about how procedure, even if it may be flawed, so long as it doesn't impede on the interests of justice on the part of the accused, then the matter can go ahead, Stephen Clotter.